Welcome to Husch Blackwell's Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing in the labor law sector for, more than 40 years, and I can tell you that in no time of my practice has labor law had greater changes than in the last 5-6 years. We began the podcast in May of 2021 following the election of President Biden, and elections have consequences, and under the Biden administration, a new National Labor Relations Board with a new General Counsel reshaped labor policies, and they were very consequential. During that time, because it was so important to stay on top of labor law issues, the family of Husch Blackwell Labor Law Counsel more than doubled in its coast-to-coast reach to assist our client. Well, we've since had another election. In the January of 2025, President Trump was inaugurated to his second but non-continuous term. And once again, we're seeing significant changes in how the National Labor Relations Board and its appointed members, the GC right now an Acting General Counsel, and the board members are going to interpret the National Labor Relations Act and its associated laws. So once again, we're continuing a wild ride of labor law. It's not likely to change soon, so buckle up and enjoy the Labor Law Insider Podcast. Welcome back, and it's great to have you joining us today. You know, it's early still in the year, the middle of January, where we're putting down this recording, and it was only a week or so ago that we had not a big change. It was all anticipated, but the swearing in of new NLRB members took place on January 7th, and we're seeing changes. We're seeing changes from the acting GC, and we're seeing changes from the General Counsel. We're going to have a traditional labor law discussion today. We're moving from our wonderful broad discussion that we had in our last Labor Law Insider podcast. And I could not welcome a better guest for this Labor Law Insider than a true insider, Terry Potter, one of my partners from our St. Louis Husch Blackwell office, but also a fellow who worked himself in the NLRB as one of their counsel and has been helping employers understand, frankly, how to have excellent employee-employer relationships, which is one of the best union avoidance techniques ever invented, but also what's going on in D.C., what's going on at the regions, what we have seen and what we might anticipate over the next several years under this National Labor Relations Board. Terry is found on virtually every one of what I call the vanity lists that are published out there, best lawyers in Missouri, and this and that. And he's been there, frankly, for a really long time because he deserves to be. While these are vanity lists, sometimes they get it right. And with Terry, they have it right. He's truly one of the finest labor lawyers that any client would be able to bring into their side of the camp. Terry, it's great to have you. And thanks so much for joining us again in the Labor Law Insider.
Well, thank you, Tom, for that great introduction. I'm beginning to blush here. Hopefully, we're going to have a good time today and talk about what we see going forward will be occurring in this space of labor law. You and I have talked about this, but it's nice to share it with others.
6 years ago or so, we were talking and we said, we ought to put together a podcast. We ought to show a little bit more into the media what it is that elections have consequences, because we were anticipating or had just had a Biden election win, and now we've had a different regime come in, a different administration. And so there's a lot of changes taking place once again. Labor law continues to be a yin and a yang based on elections. And the president has just completed the first round of appointments through the process of having a swearing in, if you will, after Senate approval of 2 new members of the board and moving from an acting general counsel to a general counsel. First, Terry, we have James Murphy, who's been sworn in as a new member of the National Labor Relations Board. He looked at this 47 years as an NLRB attorney and a consummate insider in the board. What does that mean in terms of the board process and the way that they're going to look at how employee and union rights are balanced with management or employer rights?
Well, he's probably going to have a balanced impact, frankly. Once you've been with the board that long, it's kind of certain procedures and a certain mindset is kind of ingrained in you. I don't think he's going to go off and pull that field, that's for sure. And that's probably going to be the main result of his presence on the board. And he's going to have I'm assuming, a very strong recall of relevant cases and footnotes within those cases to draw upon when they get into more difficult holdings that they want to deal with. It's always good to have that person who can go back and look at what happened 20 years ago and put things in perspective.
Mm-hmm. Well, and he'll know the regional directors. He'll know personalities. He'll know who's on staff, who's great at researching and writing decisions. He ought to bring some real interesting strengths, right?
Yeah, absolutely. Institutional knowledge.
Yeah. And then Scott Myers has been confirmed, sworn in as a member. He was the chief labor counsel at his last gig at Boeing, had been in the hospitality business on the management side at Intercontinental and MGM and so forth, worked for a stint at Morgan Lewis, an excellent labor law firm. What might he bring to the board that's going to be new, or maybe it's consistent with what we've seen over the years?
Well, I think working as an advocate is a different perspective. And he's the one questioning why certain policies are in place or should be continued to be in place going forward. He's the why guy. Well, why are we doing? Why? What's the bottom line here in terms of public policy? I think as an advocate, you think about that a lot more than if you're an insider at the board. And I think that's what he's going to bring.
Well, and there's a Biden appointee that's still there, David Porty. Am I pronouncing the last name correctly?
I think so.
He's got now institutional knowledge, and he's got his own background as a labor and union advocate. So it's not as though these folks have a complete open field to run in. There's laws and regulations and precedents. So we're going to see some of that play out, aren't we?
Well, that also, we've got a general counsel who's going to control what he believes are the cases that should be prosecuted.
So Crystal Carey, general counsel, Morgan Lewis, former NLRB staff attorney like you, obviously thought of as management friendly. What kind of impact is this going to have? I mean, we've seen a lot of interim memos from the acting GC. Do we expect this to be sort of a continued pathway, or is there going to be some other changes? Anything that we can read into this at this point?
Well, I think the new GC has made it clear he definitely wants to make some changes. And the best way to also view this is going back to when William Cohen was the acting GC and looking at all the GC memos that he rescinded from the Biden administration. Now, the current GC hasn't had an opportunity to really jump in and comment about any of these, but I don't think there's going to be any significant changes from what had previously been thrown out the window. But Cohen's laundry list of GC memos that he felt were not necessary, I think it's going to be the beginning point. It's just a matter of whether or not the new GC wants to add on to those.
Yes, we don't really expect much of a bend in the way in which GC Carey sees the practical implications of the regulations as well as the National Labor Relations Act, the LMRA. But it might be a continuation on that glide path is what we're kind of looking at.
Yeah, I mean, again, usually when it comes to Republican administrations, they're not out to expand the authority of the board. They like to stay in the lane, so to speak. Much like what acting GC Cohen said when he issued his initial memo back in February of 25, let's focus on what we're here for. And let's not lose focus on what our goals are here, which I totally agree. In particular, that was raised when there were concerns over the board's holding in the Thrive case and the expansion of remedies and settlements, which he is not a fan of, and neither am I. Trying to create these tort-type remedies and administrative proceedings, in my mind, doesn't work very well. As I said before, the purpose of these administrative proceedings is to quickly get the matter resolved and move on. And if you raise the ante on the potential remedies, employers in particular are going to dig their feet in and fight it. And therefore, it's going to prolong the whole process. And that's not the intent.
Well, we look at the charges that were filed over the 5-year run from 2021 on and up to 2024. I mean, they went up by 6,000. It encouraged more charges because there was a bigger bucket at the end of the run potentially. And it was an interesting world. I mean, all of us 4 years ago were talking about how wide open Gwen Wilcox under her regime as GC had opened this up not only to those who were in the organized environment, but really attempting to make the NLRB proceedings relevant to every employee by saying we're going to find ways in which to protect concerted activity, even though we hadn't seen that as concerted activity. And we're going to have a broad bucket of remedies that we'd never seen before. I mean, there are plenty of good remedies that the boards had, but gosh, the expansion was crazy.
Well, and in particular, again, they weren't staying in their lane. For example, they were trying to regulate non-compete provisions in the private sector. I mean, state law has covered that area for years. There's no need for the board to put their nose in the middle of that. It just creates havoc. Give it to the states. They've done a fine job of regulating that. Do what you're good at. Regulate elections. Regulate concerted activity. That's what Congress intended you to do. So do that job, not somebody else's.
And I was talking with you before we went on air, of course, and we were talking a little bit about a case I wasn't familiar with, which is the local joint election or executive board of Las Vegas versus NLRB, a Ninth Circuit case, 2011, which established, and what I believe both Myers and Murphy have said they'll respect, that requiring a 3-member majority to overrule existing precedent. And we have had cases, not just Wilcox memos that came out. You talked about Thrive, there's CMIX and Stericycle, and all of our insiders who are listening know exactly what I'm talking about when I start throwing those out, micro units with American Steel and so on. So right now, even as we move towards board starting to clear up some of the stuff that's on their case, we're not going to immediately see any overturning of those cases until another member who might be more management friendly, if you will, is appointed. But does that make any huge difference to the way in which those who are either engaged in union operations or management operations are looking at the world, the fact that there's not going to be, at least for some period of time, overruling? In other words, I guess how important are the GC memos? How important is the bend of where the board's going compared to their actual overruling, if they're going to, and they may, cases like Stericycle and CMEX?
Well, I think that's where the GC comes in terms of all these memos where he directs the prosecution or the agenda for the prosecution of cases. And if this agenda doesn't include focusing on CMEX and some of these other matters, then those cases aren't going to be presented to the board when they have less than a quorum on the Republican side. They're going to sit in either advice or the sit period, and they're not going to be issuing complaint on those cases. So it's de facto being overruled, this by not being prosecuted.
Well, we talked about Thrive, which was the case that represented to us on both sides, again, union management, employee, employer, the expanded remedies case. We've mentioned CMEX, but just to make sure that we're not talking too much inside stuff, CMEX, to me, that represents elections. Talk a little bit about that and why it's important to management or to unions that be throttled down. I personally thought it was a huge throttle up. Talk a little bit about CMEX and why throttling that down is going to be important.
Oh, in my mind, CMEX was maybe one of the worst decisions issued by the NLRB in its entire lifetime, at least in terms of how it was being implemented by the regions, in which the board and the GC set up these guidelines so that even if there were more than a de minimis amount of unfair labor practices being engaged in during a organizing campaign, that'd be sufficient to issue a bargaining order and force the union upon the employees and the employer. That's not how this is supposed to work. I mean, bargaining orders historically were extraordinary remedies. It's only when an employer engaged in wholesale, what referred to as god-awful misconduct, threats of closing down, actually closing down facilities, mass discharges, things of that nature, that a bargaining order is necessary. And frankly, they were few and far between historically in recent years. And then all of a sudden, the threat changed. And now we were having all these charges being filed and bargaining order cases issued. I myself was subject to that process. And this shoving the union down the throat of the employees. Well, literally, I had a case where we had an election and the union lost, but the union filed a CMEX charge, and we ended up getting a bargaining order. I mean, insane. The employees had already spoken. So that's what you run into, and that's what's so frustrating.
Well, it was even more frustrating when, again, another name that might be familiar to most of the crowd that listens to this podcast, but Stericycle expanded the reach of what constituted a ULP. Now you have an expanded reach, and you have the CMEX hammer that's at the end of that. And that really put employers at a really unstable place to say, how do I engage my employees in a discussion about what it might mean to get engaged with a union?
Well, and frankly, it all goes back to that gotcha mentality, which is what we shouldn't be doing here. We should be doing something more in the lines of what the DOL does. DOL provides guidance memos of all kinds. NLRB has never done that. It's always been each step in the muck. We'll tell you when it's bad muck, but you're on your own. Why? If we're going to regulate something, why don't we regulate it in advance so all things are foreseeable? And we don't have all this litigation and the expense associated with it. I've never understood that.
Well, part of this, it seems to me, has tended to make lawyers richer and employers and maybe unions poorer. That is, if you are going to get hammered with bargaining orders, or if you settled a case, you had to settle it for 110 cents on the dollar with posting all of these apologies for conduct that you don't believe constituted a ULP in any case. You say, the heck with it. Let's go fight. Let's take our chances. Maybe a judge will see this differently. Was that part of your practice over the last 3, 4, 5 years?
Oh, yeah. And then the other thing was not only just postings, but making an employer representative stand up in front of his employees and read the posting, a public shaming, I think the Sixth Circuit said, which was inappropriate. That's not how this should be handled.
Terry, that is a wonderful summary of just one of the ways in which the previous board rulings took the National Labor Relations Act and remedies or even settlements well beyond anything we had ever seen before. But it's worth continuing our discussion. But Terry, I think we're going to carry this discussion over into our next Labor Law Insider episode, where we learned a little bit more about how the unions had, and will continue to the best extent that they can, use social media to move forward with their agenda. But it's probably going to be a bit tougher with the new board. But Terry, join me for episode 2 of this, or part 2 of this discussion on the changes that we're seeing for 2026 in our next Labor Law Insider. And thank you so much for joining us. And listeners, please join us in a week or two when we get to the second part of this discussion, which you're going to find just as interesting and maybe even more so as we continue our journey into 2026 in the Labor Law Insider.